Hi, everyone. Sorry for the audio problems on the last live. If anyone's watching, can you just leave a comment that you can hear me? I'm going to give a reaction to the Jordan Peterson result in the freedom of expression fight. Just please leave a comment if you can hear me. My last attempt at live, there was no audio. Okay, perfect. Thank you so much. So I'm coming to you live. I actually just got off the phone with counsel for Dr. Peterson. So I'm going to give you the result in the case. I've reviewed it twice now. The result is disappointing. It is not the result that we wanted. So first, very briefly, I'm going to remind you what the case was about. This was a case about freedom of expression. There was a dispute over professional penalties, which were in the form of mandatory training that had been imposed or ordered on Dr. Peterson by the College of Psychologists of Ontario. And the order for professional training was as a result of public statements that Dr. Peterson had made on social media, so on Twitter, on YouTube, on the Joe Rogan podcast. And those comments were on a variety of different topics, some controversial topics, but they did not relate to the practice of psychology. And the complaints were made by members of the public, not by any individuals who Dr. Peterson had ever treated as a patient. So that's what happened. That's what the case was about. And I'll give you the result now, right off the top. The court dismissed Dr. Peterson's judicial review, and they found that the order for training was reasonable and that the college had balanced Dr. Peterson's right to freedom of expression with the public interest. This means that the order for coaching or training stands and that Dr. Peterson's fight so far has been unsuccessful. So I'm obviously disappointed in the result. I disagree with the result. And I just spoke to Dr. Peterson's lawyers, and they said that they will be seeking leave to appeal the decision. And if they are successful, if they're granted leave to appeal, we at the Canadian Constitution Foundation will seek leave to intervene again to support the right to freedom of expression. So we were an intervener in the lower in this decision that just came out today. That means that we did not represent Dr. Peterson, but we were at the hearing as what's called a friend of the court to make arguments about the broader implications of the case. We argued that professionals have private lives and regulators may not discipline them for off-duty conduct that lacks a clear nexus to the profession. And where off-duty conduct engages a charter right, like freedom of expression, regulators like the college have a heightened duty to ensure they've given full effect to charter protection. I think that the decision by the divisional court in this case could have a chilling effect on people in other regulated professions like doctors, nurses, lawyers, teachers, accountants. I don't think that professionals should have to soft pedal their speech or restrain themselves from speaking openly because they are afraid activists will weaponize regulatory bodies so that unpopular speech is penalized, even when that speech has no connection to the profession. So this decision is going to be appealed. I'd encourage you to tweet at Dr. Peterson to show him your support. His Twitter handle is readily available, or I guess his X handle is readily available. Show him your support. I think he probably needs it. This was probably a hard thing to swallow. I see your comment there. Why did the court say it's reasonable? So I'm giving you my reaction off the top. I'm going to get into the reason. So I am going to get into that. But first, I want to say that I think an appeal in this case is really, really important because the result is going to have lasting impacts beyond Dr. Peterson's case. It will have an impact on people in all kinds of regulated professions. And the right to freedom of expression needs to be given more weight than the court gave it here. And one thing that stood out was this assertion that there was harm. And I think that the mere assertion that there was harm is not enough, even though Dr. Peterson's comments were controversial. They were even inflammatory. His language is not necessarily language that I would encourage my children to use. But there's no suggestion at all that any of the people Dr. Peterson made these comments about were harmed in any way. And they were not the source of the complaints. Complaints were made by members of the public who just didn't like what Dr. Peterson said, or worse, didn't like how he said it. It's not even about what he said, it's how he said it. And actually, this is a big part of the decision itself. So I'm going to get into that too. In my view, this is not enough of a basis for action by a regulator like the College of Psychologists when it is weighed against Dr. Peterson's constitutionally protected right to freedom of expression. So Dr. Peterson, as I said, is going to be appealing. And if he's granted leave to appeal, it's not guaranteed, but if the court decides to hear his appeal, we will once again seek leave to intervene. So that's my reaction. Now let's get into what the court said. And I'm just going to summarize the decision for you. I have already given you my opinion on it, but let's go through the reasoning of the court. So the court described this case as a clash between a regulated clinical psychologist's right to speak in a certain manner and the regulator, the college's power to require a member to moderate that speech. And the court affirmed that when an individual joins a regulated profession, they do not lose their charter right to free speech, but they take on obligations and must abide by the rules of the regulatory body that may limit their right to freedom of expression. These are not pajamas. The person who commented I'm in pajamas. I am not in pajamas, I promise. This is just lounge wear. Because I work from home, so I like to be comfortable. So that's how the court described this. It was a clash. The court also found that the decision of the college had adequately and reasonably considered Dr. Peterson's statements in the context of the college's statutory mandate to regulate the profession in the public interest. The court said that the coaching or training that had been ordered for Dr. Peterson, they said it's not disciplinary and it doesn't prevent Dr. Peterson from expressing himself on a controversial topic or topics. And the court held that coaching has a minimal impact on his right to freedom of expression. Now, I disagree with this. Obviously, a big part of the argument at court was that this was discipline, even though the college said it is not discipline. And part of the reason it's discipline is that Dr. Peterson pays for this coaching himself, and he has to pay for it for an indeterminate amount of time until the coach and the regulator are satisfied that he's going to act the way they have decided they want him to act. So I think it is disciplinary. And I think that imposing such big cost and indeterminate cost restraints on a professional, I think that is not a minimal impact on freedom of expression. I mean, this could go on for years and is all paid for out of his pocket. So a lot of the decision spent time on what's called the standard of review. This is an administrative law principle. And the question on standard of review is whether an administrative decision maker, here it was the College of Psychologists, whether or not their decision was reasonable. It doesn't have to be a perfect decision. The tribunal or the college here is not held to the same standard as a court. And there is some deference that the court gives to the administrative decision maker. If you're really interested in the standard of review, then I'd encourage you to read the decision. This was not the issue that we intervened on, so I won't spend too much time describing that part of the decision, but you can read it in the decision, which is linked in the document I put a link to in the description of this video. So very briefly, the court found that the college did conduct an appropriate balancing of Dr. Peterson's right to freedom of expression and the statutory goals and objectives of the college, the regulator. The court found that the regulator approached the matter from the perspective first of fulfilling the College of Psychologists' statutory mandate to regulate the practice of psychology in the public interest. And this, the court said, included considering the conduct of Dr. Peterson in light of possible risks to the public. Then it considered how to balance the statutory objectives in order to minimize any impact on Dr. Peterson's charter rights. And the court held that the fact that the college did not provide a detailed discussion of the value of freedom of expression, it was kind of like this throwaway line in the college's order for training. They said, even though that's all that Dr. Peterson got, that doesn't mean it wasn't properly or appropriately considered. And further, the court said that the college shouldn't be expected to give a detailed discussion of the right to freedom of expression. The college and the body that ordered this training, the court said, is essentially a screening body. It reviews complaints and investigations, and where appropriate, sends cases to disciplinary hearings for adjudication, in which case then it's not even subject to judicial review as the process hasn't run its course. So this sort of links to the notion that this was not actually a disciplinary matter, which I fundamentally disagree with, because, as I said, this is an indeterminate amount of training at a cost to Dr. Peterson himself. So the court also held that the order for this training, this mandatory training at his own expense and for an indeterminate amount of time, it doesn't prevent Dr. Peterson from expressing himself on issues that are of interest to him or to his audience. Rather, they said the order for training is focused on concerns over his use of degrading or demeaning language. And this was something the court said he had already been given advice about in 2020. So I didn't mention this off the top, but not everyone might be familiar with this, but there had been, prior to these complaints that brought this order that this case is about, the 2022 comments that Dr. Peterson made, there were also tweets he had put out in 2020 that also had complaints brought against him, resulted in complaints against him. And those complaints, the college looked at them and they didn't do anything about the 2020 complaints other than suggesting that Dr. Peterson reflect on them. And they didn't order anything. They made no order, even though, arguably the 2020 comments were actually more controversial or spicy than the 2022 comments. So based on this advice from 2020 that was not an order, the court found that now in 2022, he'd been given this warning that was not really a warning, it was just advice. But the court said because he'd already been told this, requiring coaching now because he didn't listen to that 2020 advice, it's a reasonable next step to now order training. And the court found that the order for training or coaching proportionately balanced the statutory objectives of the regulator, the College of Psychologists, against Dr. Peterson's charter rights, and that it was a minimal impairment, even though it's at an indeterminate cost for an indeterminate period of time. And they said even if they were impaired at all. So they were minimally, this order for coaching is minimally impairing, if impairing at all, even though, as I said, it's out of his own pocket and could go on forever. So the court held that the decision of the college was also, it met these standards of review requirements that the order of the decision maker is justified, intelligible, and transparent. Those are administrative law requirements. And they held it wasn't necessary to engage in whether Dr. Peterson's comments were actually even supported by the facts or were his honest opinion, because they said concerns about the public interest can arise from the nature of the language used, not the validity of his opinions. And that's a quote from the decision. So it's not what you say, it's how you say it that's justified and reasonable in having this sort of disciplinary action taken against you. So they gave two examples in the decision of it's not what you said, it's how you said it. And the first was comments Dr. Peterson made calling his former client a former client vindictive. This was on the Joe Rogan podcast because this former client had fabricated very serious allegations against him. And these allegations were determined by the regulator to have been false and fabricated. Well, the court found that even though that complaint against him by that client was unfounded, it doesn't mean they shouldn't be concerned with him complaining about this unfounded, fabricated complaint, or they shouldn't be concerned. It doesn't mean they shouldn't be concerned that he called this client vindictive. The court wrote that there is nothing unreasonable about being concerned when a regulated health professional attacks a client or patient, regardless of what they have done. And I just don't agree with this. I think a false or a fabricated allegation was made, and it doesn't damage the profession in any way for Dr. Peterson to call out these fabricated allegations for what they were, for him to defend his reputation. I see a question there. Can he appeal the case? Yes, he can appeal the case. And he is, in fact, I spoke to his lawyers just before going live, and they have told me he will be appealing. And if he is successful in getting leave to appeal, we will be intervening, or we'll seek leave to intervene. So to follow up on this question of it's not what you said, it's how you said it, that the court talks about here, they gave another example, and it was on the Joe Rogan podcast. And on the Joe Rogan podcast, Dr. Peterson made some comments where he was calling out the hypocrisy, or what he viewed as the hypocrisy, of progressive left-wing activists advocating for certain climate policies that Dr. Peterson said can hurt the developing world. And he said something along the lines of, well, it just hurts poor children, and who cares about that? Clearly being sarcastic. He's calling out the hypocrisy of his political opponents. Well, the court held here that even while his comment about poor children may have been sarcastic, it was still open to the college to be concerned about him making demeaning jokes. The court held that sarcasm is commonly used to insult, demean, or degrade, even though here he is kind of making fun of his political enemies. He's not making fun of poor children. He's making fun of people who purport to claim about poor children, but actually don't. So this really makes no sense to me. The sarcasm here is aimed at these left-wing activists that Peterson dislikes. It's clearly a comment on social and political issues, which is wholly unrelated to the practice of the profession of psychology. So I think the idea that the court thinks it's completely reasonable for there to be this disciplinary action against Peterson for making a joke about some activists it's not reasonable in my view. There's another example the court gives about this language. It's not what you say, it's how you said it. And it was this instance where Dr. Peterson addressed Elliot Page as her, and by Elliot Page's prior name, Ellen Page, as well as a comment calling a city councilor a thing and a doctor a criminal. And the court held that this concern that the college had arose not because of his personal views, but because of the language that he was using. He was using these mean words. And this is the same about they raised the same concern about his negative comments on a model on the cover of Sports Illustrated, and calling Jerry Butts, an advisor for Prime Minister Trudeau. Dr. Peterson called him a prick. And the court said on its face, the language here raised professionalism concerns, is not necessarily for the college to engage with Dr. Peterson's motivation for making the comments. It's just the language. So it's not what you say, it's how you say it that's being regulated here. And I think that is a big problem. The court also found that the college was focusing on the harm from the language used, not noting that its concern that potential harms could be undermining public trust in the profession of psychology and trust in the college's ability to regulate the profession in the public interest. And the court expressed concern that the public statements of the nature Dr. Peterson had made also raised concern about his ability to appropriately carry out his responsibilities as a registered psychologist, and that public statements that are demeaning, degrading, and unprofessional may cause harm both to people that they are directed at and to the broader communities. Now, remember, no one that Dr. Peterson made these comments about actually complained. There is no evidence of actual harm. There's just Dr. Peterson uses mean words, and there's just this mere assertion of a hypothetical harm. The court then also looked at how the College of Psychologists, when ordering this penalty against Dr. Peterson, how they balanced the public interest and Dr. Peterson's charter right to freedom of expression. And the college, they said, acknowledged, I guess it was in one short throwaway sentence, that he had a right to freedom of expression, that his conduct on Twitter is protected by the charter, and is but the college noted that while he has a constitutional right to freedom of expression, as a member of the College of Psychologists, he's also obligated to maintain the professional standards of the college, which they said includes ensuring that any public statements made are consistent with the professional standards, policies, and ethics currently adopted by the college. This is especially the case where Dr. Peterson identifies himself as a member of the profession. Now, Dr. Peterson has argued that this very limited reference to his right to freedom of expression was not sufficient or proportionate. It did not properly balance his right to freedom of expression. The college just sort of said, we know that he has this right to freedom of expression, but we're going to impose this penalty anyway because the stuff he said is mean. I mean, to paraphrase. The court disagreed. Justice Chabas for the Divisional Court wrote that it's clear from the history and context of the proceedings that the college was well aware of the importance of the value of freedom of expression and of Dr. Peterson's position respecting that right. And the court found that the college, in ordering this training, had appropriately balanced freedom of expression with their statutory objectives. Now, on the statutory objectives, the court considered what those objectives are and the context of Dr. Peterson's statements. They found that his statements are not personal comments made in conversation with friends or colleagues, but they are public statements to broad audiences. And that Dr. Peterson himself references his very large following on social media and his best-selling books. And the court found that the Code of Ethics of Psychologists explicitly addresses public statements and prohibits degrading and demeaning comments by members when they are making public statements. And the court also held that the argument that Dr. Peterson made, that he's speaking in his personal capacity, not as a clinical psychologist, the court found that Dr. Peterson's own conduct and statements undermines that position. The court found that Dr. Peterson describes himself on Twitter and on Rogan and on YouTube as a clinical psychologist, that he sees himself as functioning as a clinical psychologist in the broader public space, even though he no longer sees clients in a clinical practice. And the court found that Dr. Peterson claims he's helping millions of people, as he puts it, and that he is still practicing psychology in a more diffuse and broad manner. In short, the court wrote that while Dr. Peterson's lawyers may argue that his comments are off-duty and outside of his role as a psychologist, Dr. Peterson himself doesn't see it this way. The court knows how Dr. Peterson views himself, I guess. The court found that representing himself as a clinical psychologist is, when expressing his views, even these controversial views, it's important to him. Although it's not as if he, in advance of every tweet, he says that I am making this comment about a Sports Illustrated model as a clinical psychologist. He just doesn't do that. But still, the court found that he somehow is always making these comments in his capacity as a clinical psychologist, I guess because it's in his Twitter bio or something along those lines. The The court found that identifying himself at the beginning of interviews uh, as a clinical psychologist adds credibility to his statements because they said, as a regulated health professional, he holds a position of trust, confidence, and responsibility in society. And the court wrote that Dr. Peterson can't have it both ways. He cannot speak as a member of a regulated profession without taking responsibility for the risk of harm that flows from him speaking in that trusted capacity. I just fundamentally disagree. I think that you have a professional hat that you wear when making a professional statement. Perhaps you can be subject to regulation when but there has to be a clear nexus, and there is not a clear nexus in all of these statements. I don't think it's enough for it to merely say at the beginning of an interview that is his profession. He's a psychologist, and then every single thing he says in that interview is therefore captured by the regulator, or for him to place in his Twitter bio that he is a clinical psychologist, and then everything that appears on his Twitter feed is suddenly being tweeted as a clinical psychologist. So that was the decision. As a result of this reasoning that I've outlined here, the divisional court dismissed the judicial review and ordered Dr. Peterson to pay costs of $25,000 to the College of Psychologists. This amount, $25,000, was agreed on at the hearing, that the winning party would receive costs from the losing party. So let me know what you think of the decision. As I said off the top here, I fundamentally disagree with this decision. I think it will have a chilling effect on professionals in other capacities, doctors, lawyers, nurses, teachers. That I think that the balance was not right here, and that there needs to be a very clear connection between the conduct and the profession. The statements need to relate to the practice of psychology, or if it's another profession, the practice of medicine, practice of law, etc. So let me know what you think of the decision. I encourage you to tweet at Dr. Peterson to show him your support. I'm sure that this was a frustrating result for him. So if I was in that situation, I mean, I would like, you can tweet support at me too, because I'm also frustrated with this decision. But of course, it has a very, very direct impact on Dr. Peterson. And I am very sorry for this result, and I think it's wrong. So thank you very much for tuning in to watch this. You can always support the work that we do at the Canadian Constitution. I can't get to all these comments. The comments are coming fast and furious because I think everyone's probably as mad about this decision as I am. But I appreciate you all coming on to I will see you soon.